Hello, everyone. My name is Ariella Wagner. I'm the founder of SunRay Construction Solutions. We help thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights. Today, we have a very important webinar in case you actually missed that deadline. Oh shit, I blew my deadline. Now what? So without further ado, I'd like to introduce the extraordinary construction attorney, Alex Barthet.
Thanks, Ariella. My name is Alex Barthet. I am a board certified construction lawyer here in the state of Florida. And today we're going to talk about what to do if you missed a deadline. And trust me when I tell you, it's not as bad as you think. You probably have a lot more options than you are aware of. So let's get right into it. If you have any questions, go ahead and use the GoToWebinar chat box, which should be on your computer. We'll answer all the questions at the end. Please do not include the names of any people or companies in your questions. So let's talk about today's agenda. What are we going to go over? Let's start with the basics. What are the notice to owner and lien rules? You have to have an understanding of what those are in order to have a foundation so you can understand what happens if you miss them. Then we'll talk about some common exceptions that we see. So you may have thought you missed a deadline, but you actually didn't, because there's an exception in the lien law that gives you the opportunity to still send a notice or a lien, even though you think you can no longer do it. We'll talk about other bonds that exist. So on public and private jobs, there may be other bonds you can pursue to go after in case you lost your lien rights, or actually in addition to your lien rights. Then we'll talk about some other means of recovery, how to sue for breach of contract, how to sue for unjust enrichment. And as I said, we will answer any questions that you have at the very end. Just go ahead and submit them throughout the presentation. So let's get right into it. Let's talk about the basic lien and notice to owner rules. So a notice to owner is a document that's required to be sent in most cases in the state of Florida in order to preserve lien rights. It is a written document prepared by the lienor, and it must be received within 45 days of your first work or delivery of materials to the site. Now, there's an exception, which is if you get it to the great folks at SunRay Construction Solutions with enough time that they can bring it to the post office by the 40th day, 40th day, then whether it actually arrives, whether it's delivered, whether there's no one there to pick it up, whether the mail truck blows up, as long as you give it to SunRay in time and they bring it to the post office by the 40th day, that notice to owner is considered served, irrespective of if it ever gets there. This is a great reason why you want to use SunRay and why you want to make sure you deliver, you start this process early. So the next rule is that the claim of lien for work on private projects and the notice of non-payment, which is a claim on a bond for both public and private projects if there is a bond, must be served no later than 90 days from your last work or delivery of materials to the project site. Quick tip here, both the 45 and the 90 days are counted starting on the day after your either first work or last work on the job. You count every single day, including weekends and holidays from that date. And the 90th day, if it happens to land on a Saturday, Sunday, or legal holiday, then it rolls to the next day. So if I'm calculating my notice of non-payment deadline and today was my last day of work or delivery of materials to the site, tomorrow is day one. I count every day all the way through day 90, including weekends and holidays. And if the 90th day happens to land on a Saturday, then it rolls to the Sunday. And if Monday happens to be a federal holiday where there's no mail, then it rolls to the Tuesday. That's how you calculate those days. And then you need to file a lawsuit to foreclose on your claim of lien no later than 1 year from the recording date of the claim of lien. So if I record my lien today, I have 1 year to file the lawsuit. On a claim against a payment bond, I have 1 year from my last work. So it's not the day that you send your notice of non-payment on the bond, it's the day you last do work on the project to preserve your claim on the bond. Now, there are many, many exceptions to these rules, and many of the exceptions have exceptions. So just be aware of that. Now, let's go through some of the most common exceptions that we see, which is why I say, did you really even miss your deadline? So first, there is no notice to owner that's required when you have a direct contract with the owner. So if I am a plumber and I am hired by a homeowner to renovate their bathroom, then I don't need to send a notice to owner because I have a direct contract with the owner, and therefore I don't need to serve this document to preserve my lien rights. Now, I'm here to tell you that our most successful clients send notice to owners no matter what. They have a process in their office and they say, it doesn't matter who we're working for or what we're doing, but any project over this amount of money, we just send notice to owners and it's automatic. So I still recommend that you send one. It's a great collection tool. People take you much more seriously when they get a notice to owner from you. They're more likely to pay you even if you didn't need the notice to owner. So that's rule number or exception number one. Here's another one. No notice to owner, which is technically called a notice to contractor, is needed when you have a direct contract with a bonded contractor. But again, as before, you should still send one. So what do I mean? Let's say I'm the plumber and I'm doing work for a general contractor on a private project. And that private project has a bond. So this general contractor went out and got a payment bond because either the owner required it or the lender required it. So I'm a subcontractor to a bonded general contractor. I do not need to send a notice to owner or a notice to contractor in order to have a right against the general contractor's payment bond. Now, as I said, you should still send one, but it's not required in order to have a claim against that contractor's payment bond. This is true for both public and private jobs. So if I'm a plumber on a school board project for Broward County Schools, again, and I'm the subcontractor to a bonded contractor on that project, I don't need to send that notice to contractor. I also don't need to send the notice of non-payment. That's, if you remember, that's like the claim of lien. That's the document that gets sent 90 days after your last work to make a claim on the payment bond. But I don't need to send a notice of non-payment when I have a direct contract with the bonded contractor only on a public project. So if I am that plumber on a school board project and I don't need to send my notice to owner, my first notice, the one in 45 days, I don't need to send that. I also don't need to send the notice of non-payment. That's the notice within 90 days. So the only requirement that I have if I am doing work on a public project and the general contractor has a bond and I'm the sub is to file a lawsuit within 1 year of my last work on the job. So I've had clients come to me and say, Alex, I really screwed up. I didn't send my notice of non-payment on time. And I would say, okay, well, tell me about the project. Well, we're the shell contractor on a bonded project. I said, okay, great. Tell me about the project. Well, it's a project for the Miami-Dade County School Board. Well, great. You don't need to send either notice. So you're fine. You can still bring that claim. So just be aware that there are many exceptions that don't necessarily require these documents. You should not assume that because you didn't send a notice or didn't send a notice of non-payment, a notice to owner, a notice of non-payment, that you lost your lien rights. There's one other big one, and that is on a bonded project. So if you are working on a project that has a bond, the 45-day notice to owner, again, that's technically on a bonded job called a notice to contractor. does not even start to run until you have actual or constructive knowledge of that bond. So let me give you a very specific example that happened to a client of ours. We represented a mason on a public project in Homestead, Florida. Our client was a subcontractor. So there was the public owner, the bonded general contractor, the subcontractor, the shell contractor, and then our client, the mason, a subcontractor. Now, what happened on this project is that the bonded contractor failed to record a copy of their payment bond. So there was no existence of it in the public record. Well, that's a requirement. The law requires that a bonded contractor on a public job needs to record a copy of the bond in the public records in order for everyone to know of the existence of this bond. Well, they didn't do that. Someone screwed up in their office. The subcontractor, the party that my client had a contract with, went out of business, actually filed for bankruptcy. So we can't sue for breach of contract because they went out of business. So my client comes to me and says, I'm owed $100,000. I haven't been paid. I did all the work. I finished the work months ago, 4 months ago, 5 months ago, and I've been off the job. I can't sue my customer because he filed for bankruptcy. Alex, am I totally screwed? And we did some research and we found out that this contractor failed to record a copy of the payment bond. So what does that mean? That means that these deadlines didn't even begin to start to run. So we served once we were able to locate a copy of the bond, we served a copy of the notice to owner. Because my client was a sub, so he needed to do that. We served a notice of non-payment, and then we filed suit. And after a little bit of fighting, the contractor realized that because they failed to serve this notice, that they were on the hook, and they paid my client the $100,000 he was owed, all of his interest, and all of his legal fees. So had my client just looked at the situation and said, well, geez, we really screwed up, we didn't send our notices, and never called me, he would have never gotten the money. So the moral of the story is, don't assume because you miss a deadline or you think you missed a deadline that there isn't some other rule or exception that would give you rights. So make sure to pick up the phone, call a lawyer, board certified construction lawyer, someone that's skilled in this area of the law to be able to help you because maybe you still have rights. Now, we offer this very interesting tool. It is called the Lien-O-Matic. You can go to Lien-O-Matic.com. And it is a handheld tool that gives you all of the rules and many of the exceptions for private jobs, public jobs, FDOT jobs, Miller Act projects. So if you're ever wondering, well, what notice do I need to send and when do I need to send it? We have this tool for free completely. If you go to Lien-O-Matic.com, enter in your information, we will put this in the mail. You'll get it within a few days. We've given out more than 2,000 at this point for free. It's a great tool to have on your desk. So again, go to Lien-O-Matic.com. So are there other avenues that you can pursue if you did blow your deadlines, or maybe in addition to the standard claims? And the best one we have found is to look for another bond on a job. And we find these bonds hidden all over the place, even when you may otherwise have lien rights. So you typically need to be further down the chain of contracts. So this usually applies if you are a subcontractor or a material supplier to the subcontractor, or a material supplier to the subcontractor. And what bond is this? So if I'm a GC on a project, maybe it's public, maybe it's private, and I want to get a little extra assurance that my shell contractor or plumber or electrician or glazing contractor is going to finish this job, or maybe it's a requirement by the owner that I get my subs to either give me bonds or bond back to me because I, as the GC, also have a bond. I may ask in my example, shell contractor to give me a bond. So just like there's a payment and performance bond that a general contractor may get that they give to the owner, and that's the payment bond that we're talking about that you make a claim on, which is recorded in the public record, there may be these other bonds with the subs. So if I am a subcontractor, so maybe I'm the mason to the shell contractor, if that shell contractor issued a payment bond, I have rights against that payment bond. Even if I have lien rights, I can still make a claim on the subcontractor's payment bond. Even if the GC has their own bond, I can make a claim on the subcontractor's payment bond. And even if I blew all of those other deadlines, I may still have rights on the subcontractor's payment bond. So the first question is, how the hell do you get your hands on this document? Because it is not recorded in the public record, because it is not what's considered the statutory bond. That's the general contractor's bond. So where do you get it? You could ask the subcontractor for it. And technically, the subcontractor is supposed to give you a copy if you ask for it. When I say ask for it, you send a written request for it. I would start with an email, but there is a formal statutory request that you can send. But the person that's most likely to give you a copy of this bond, if it exists, is the general contractor. And that's because the general contractor wants to make sure that you don't lien the job. So if they give you another bond to go after, that reduces the likelihood that you may make a claim on that bond, number one. And two, on the property. And number two, if they have their own bond on the job and they give you someone else's bond, well, now you may go after that bond instead of going after their bond. So the person that's most likely going to give you a copy of this bond is the general contractor. So that's the person you should direct your request to, but it's still a good idea to send a copy request to the subcontractor. Just know that the process in order to preserve your rights on that subcontractor payment bond is whatever is in the bond. So that's why you have to get your hands on it so you can see, because you're going to then read the bond and then you're going to do what the bond says. So sometimes the bonds say you need to send us a copy of this, this, and this, and that's how you're going to make a claim. Sometimes it says you need to send us a notice of non-payment. Well, that's how you're going to make a claim. Sometimes it doesn't say anything. It says, you know, if you have a claim against us, you just need to sue us, the bonding company. So again, if you're either the subcontractor or material supplier to the sub or the sub, then you need to look for a copy of this subcontractor payment bond. So there are a few other ways to protect your rights. This again is in addition to lien and bond rights, but sometimes it may be the only claim you have. And that is the first one we're going to talk about is how to sue for breach of contract. So if you have an agreement with another person or entity, and ideally it's in writing, but it doesn't have to be, it can be a proposal, a quote, an invoice. You can sue someone to pay you. So if I am a general, let's say I'm the plumber, and I sub work out to you as my subcontractor, and I give you just a purchase order, or maybe you sign my contract, and now you do the work, you forget to serve the necessary notices, you have no lien rights, there's no bond on the job. You could sue me for breach of contract, right? I hired you. There's a writing or invoices to support the fact that money is owed. And if I don't pay you, you can take me to court and sue me. Now, what you have to be most careful of is that in breach of contract cases, if in my contract with you, I have what's called a pay when paid provision. You can look on the SunRay website of old webinars. We've done webinars on pay when paid provisions. But if you have a pay when paid provision in your contract, then if I haven't been paid by the owner or the contractor, I don't have to pay you. It's got to be a very specific contract provision in writing in the agreement. But if it's there and it's valid, then you may not actually have a right to sue for breach of contract. But there is one other claim you could make, and that's to sue for unjust enrichment. If you conferred some benefit, that's the enrichment, and you've not been paid, that's the unjust part, you have a legal action against anyone that received the benefit. Now, that benefit could have been to the contractor who was paid and didn't pay their bills. Maybe it's the owner because I installed cabinets and they didn't pay for those cabinets. You have a legal claim to pursue in that situation. Typically, it's used against a party that is further up the chain, such as the owner. So typically when we sue an owner, let's assume we represent a subcontractor, we may sue the contractor for breach of contract, depending on if there's a pay when paid provision. If we have lien rights, we'll pursue the lien. If there's a bond claim, we'll pursue the bond claim. But sometimes we also include the owner and sue them for unjust enrichment to add them to the legal case. But just know that if you sue the owner for unjust enrichment and maybe you haven't been paid, but they paid all their bills, meaning it wasn't unjust for them, you may not have gotten the money, but they justly paid the contractor, then you have no claim for unjust enrichment. So you also have to be aware that there may not be a right to recover your legal fees in this situation because there's no legal right to recover legal fees for an unjust enrichment claim. So now let me give you one last bonus tip. If all else fails, and that is to send a late notice to owner anyways. So we've been on both sides of this situation for our clients. Sometimes we've had clients who had no rights, they sent a notice to owner, and that notice to owner was used as a collection tool in order to preserve, in order to get paid. And sometimes we represent owners and contractors who get a seemingly late notice to owner, and then we have to deal with it. Now, remember, a notice to owner is not an encumbrance on real property. So if you record a lien that you know is no good, that is a fraudulent lien. However, if you send a notice to owner, that's just a document in the mail. It's not an encumbrance on real property. It doesn't lien, it's not a lien. But what happens is if, let's say I'm the material supplier on a project, so I'm a material supplier to a subcontractor, and I haven't been paid, and I screwed up my deadlines. If I send a notice to owner to the contractor, what is the contractor going to do? They're going to say, well, man, I got this notice to owner. I don't know when the material was delivered. That, you know, I'm not watching the job so carefully to know when each piece of material was or wasn't delivered, but I have this notice to owner. So I'm going to go to the subcontractor and say, hey, I got this notice to owner. I can't pay you, subcontractor, until this notice to owner, until I get a release from that vendor. And the subcontractor may say, well, look, this notice to owner's late. They weren't here. As the contractor or the owner, I'm going to say, that's not my problem. I'm not getting into that. I have a notice to owner. I need a release. You figure it out. So just know sending even a late notice to owner may in fact get you paid. So let's recap. You need to know the basic notice to owner and lien rule deadlines. Again, you can get your Lien-O-Matic to help you understand what those rules are. You need to exhaust all available exceptions to the lien law. Again, not that you're expected to know them. The Lien-O-Matic will help, but you probably should be consulting with a construction lawyer. Look to see if the subcontractor is bonded. Maybe you have a claim on that subcontract bond. And you always have the legal avenues of breach of contract and unjust enrichment. So with that, Ariella, do we have any questions?
At the moment, we don't have any questions, but what comes up really frequently is, you know, I missed this deadline and I'm owed only, say, $5,000. I've missed my deadline. What can I do? You know, and I know we have another webinar on that, but the big issue is, what do we do?
So my advice generally is, you know, to run through some of those items that we talked about. Maybe you still have lien rights or bond rights that you didn't know about. But if those are all exhausted, then if the amount of money is so small it doesn't make sense hiring a lawyer, you can take them to court yourself in small claims court. Small claims court is now a little bit more accessible. They changed the jurisdictional limit from 5,000 to 8,000. It's suspected that they're going to eventually raise it to 15,000 soon. So what does that mean? That means you can file the legal case yourself. You don't have to hire a lawyer. Um, and it's an abbreviated process in order to preserve your legal claim without having to spend the money with a lawyer. The best way to find out the rules on how to bring a small claims case yourself is to type in the county where the debt is owed. So if you're in Martin County, type in Martin County Small Claims Court in Google. Almost certainly one of the first pages is going to be the clerk of court website in that county, which has a page dedicated just to how to bring a small claims case. It has all the forms, it has instructions. It's not complicated. It's a little intimidating, I have to admit, if you've never done it before, but it's a great way to preserve your rights with respect to small amounts of money.
Right, that happens all the time. And people, one moment there's some more questions. And you could certainly write a Google review while we have quite a few questions on this topic. And again, the real issue is when it's under a dollar amount, attorney will take the case, but the case is even, it's not even worth it again because it will cost more to fight the case than actually to collect what's owed, which is such a frustrating feeling for the people that are listening on this webinar. One of the other parts of it is, what about if they had that agreement in place and they have the attorney's fees and collections costs? Because that's a big part of it, Alex. People get really frustrated, like, my goodness, I already am owed $8,000 and I have to give the attorney $5,000 to obtain his services. So maybe you could speak for just a moment on that.
Sure. My first suggestion again is to go back to the idea of, for small amounts, you should consider doing it yourself, going to small claims court, because just as Ariella mentioned, if you hire a lawyer, they're likely going to charge you hourly. And for those small amounts of money, just the amount of time it's going to take at that hourly rate is going to put them at a number that is at or close to the amount that you're owed. Now, you may be able to recover it if you have the right to recover legal fees, maybe via a lien, maybe via a written agreement that says the prevailing party gets their fees, but it doesn't stop the fact that you're going to have to pay the lawyer, and there's no guarantee that you're going to win, and there's no guarantee that you're going to collect. And even if you get the judgment, which means you won the case, now you actually have to collect. Do they have a bank account with that much money in it that you can garnish? Do they have other property that you can execute on? Again, all of that takes time and money. It is not a great system. You're better off being owed $50,000 by one person than 10 people owing you $5,000, just based on the economics.
So the next question, we have three more, and then can we send an NTO with a change order if we miss the initial deadline?
The answer technically is no. So what happens sometimes is people perceive that I don't need to send my notice to owner until I'm owed money. That's not the rule. The rule is you need to send your notice to owner within 45 days of your first work, whether or not you're owed money in that period of time. So the short answer is, if I've done work and my first work was 180 days ago and I didn't send a notice to owner and I needed to, your notice to owner is late. There's no fixing that. Unless you have a DeLorean that goes 88 miles an hour and you go back in time, you cannot fix this problem. So the answer, unfortunately, is no, at which point you have to try to employ some of the tactics that we talked about in this presentation.
Okay. So we do have some additional questions, which I'm going to email the attendee so that we can continue. Do not worry. I see your questions and I don't want you to worry. We will have them answered for you, unless you want to take another moment, Alex.
Sure, we might as well. Let's go ahead and answer the questions.
Okay. So this one person says, I have a massive project. And it's each, okay, so also I had cover myself when I serve, how do I cover myself with a big complex of an apartment, and they pay unit by unit as I finish each unit.
I think I understand the question. So the
Yeah,
question is, how many notice to owners do I need? And the answer is pretty straightforward. You need to serve the number of the number of notice to owners that you need is based on the number of contracts that exist between the owner and the contractor. So if I'm a roofer on a townhouse project and I have one contract for 10 townhouses, now that contract may say I am only getting paid when I finish each unit. That's the payment issue. That is not that does not deal with my lien rights. So I would, in the example I gave, one contract with a townhome community, 10 townhomes, and I'm doing each of their roofs, I would serve one notice to owner that would cover all 10 pieces of property. So even if I get paid by each unit, I'm still protected. If I sign 10 contracts, so if each townhome made me sign one contract with each townhome owner, then I would need 10 notice to owners. And if I was not paid for all of them, I would need 10 claims of lien.
and if you were hired directly by the apartment building, and this what you would do, you certainly could still send your notice to owner. But if you're getting paid after you finish it, and that was the agreement, then you need to be extremely careful, take photographs of everything you're doing. And you could, unless there's something in your contract that prevents you from stopping work. So if they say whether you get paid or not, you have to continue, which I highly doubt is in your agreement. You want to be very careful there. But if they're not paying you, then you do have the right to stop working. So that's very important as well. That's in another webinar that we're giving about stop work, making sure that's not in your agreements, so that if you're not paid, you don't have to continue working. So two last questions here. What if I find, unless you wanted to add anything to that, Alex?
No, go ahead.
Okay, what if I final, sorry, bear with me one moment. Let me just read this. Okay, I believe that the question is, what if I provided a final on my project, then go out again? Does that deadline start all over again? And the person that asked that question, if you would just verify if I read your question correctly, that would be great.
So if you give a final lien release and you go back out, you need to serve a new notice to owner in order to have lien rights.
Perfect. Yes, that was the question. You want to be incredibly, incredibly careful with giving your finals.
We have
And
one more, Ariella.
how should I handle the NTO if the job lasts 3 years and the complex pays the job after I finish each apartment?
That's okay. There's no, so the document that kicks off a project is a notice of commencement. Again, I'm going to assume that you have one contract for this entire project and you expect it to take 3 years. So there's a notice of commencement that's likely been prepared and recorded. It should have a duration on it. The standard duration of a notice of commencement, if you don't fill in that form, that blank on the form, is 1 year, but you can make it take 3 years. So you could say this notice of commencement will last 3 years. No later than 45 days from your first work, you serve a notice to owner, because in my example, the one that we're talking about now, I said you have one contract for that notice to owner for that project. So if you only have one notice to owner, or one contract, then you only need one notice to owner. So what you can do is every time you do work and every time you get paid, you would give a partial release for each unit. So you'd be releasing each area, each unit as you get paid. But if you don't get paid, you would put a lien on the property. And again, that lien would need to be recorded no later than 90 days from your last work on the project. So irrespective of whether the project is 3 weeks long or 3 years long, the process is identical.
Okay,
Any other
great.
questions,
Well,
Ariella?
we don't have any other questions. However, we are here for all of you that attended this webinar because there's a reason why you attended it. So if you do have any questions that you think of after the webinar, please feel free to reach out to us anytime, and our contact information will be at the end of the webinar.
Yes. So sometimes you are asked to give a conditional release or give a release and you want to make sure it's conditional. We offer this free stamp, makemeconditional.com, makemeconditionalstamp.com. Just fill out the information and we'll send it to you for free. We do these webinars every month on various topics. So the next one is April 11th, 3 contract provisions to avoid at all costs. And then on June 14th, I recorded a lien. Now what? How do I get paid? We'll walk through each of the steps to make sure that from the recording of the lien to getting green dollar bills in your bank account, we will talk about each and every one of those steps. The reason there's no event in May is because that's actually when we have our live event, which this May will be in Boca. You can go to the sunraynotice.com/education page, learn all about our upcoming webinars and live events in the rest of 2023. As Ariella said, we're here to answer any questions you have. Here's our contact information. Feel free to send us an email or give us a call. Thanks, everybody.
Thank you very much and have a sunny day.